Welcome to session 6 of European Entrepreneurship and Innovation at Stanford Engineering School. Today is February 26, 2018. My name is Burton Lee. I'm the course instructor, and today we're covering the really important topic and under-discussed issue here in the Valley of EU data privacy rules and how they're affecting what lessons and risks can be taken for Silicon Valley corporates and startups and US in general. The alternative title for today's session is, if I turn this on, the European Union invades Silicon Valley. And I mean this quite seriously. I think as we'll see today from our speakers, the level of legal intervention, but also operational changes that are being required of Valley companies go all the way to the level of re-architecting products. It's not just the legal teams that are affected here. Of course, it affects data policy, data management, but this goes, in some cases, goes all the way to re-architecting products, but also reshaping how product teams are formed and managed. So it's quite significant. And we haven't seen this level of external legal intervention really at quite this level at any time in Silicon Valley's history. So today is, as I mentioned, session 6. Our speakers today come from our current former general counsels, privacy counsels at Valley Corporates. One of our speakers, Sabrina Ross, is former counsel with Uber and Apple, responsible for GDPR and privacy. And Leila, so we never actually settled on pronouncing your last name. Golchehreh is currently senior counsel for privacy with Adaptive Insights, an enterprise software company. You'll see them along 101. We also have a Valley European investor, VC here, Marcel, representing SpeedInvest out of Vienna, but also wearing the hat of VP of Business Development for a very interesting startup in Berlin called Aircloak, which is designing, manufacturing, producing, selling GDPR compliance software products and services for corporates in Europe and the US and around the world. And then finally, we have Marcel Taskova, who did her LLM here at Stanford. Yes. Yeah, Fulbright scholar from Bulgaria, and is currently senior associate, and you gave me a new title just a few minutes, senior privacy advisor with Fieldfisher, which is a UK law firm, one I'm not personally familiar with until we discussed this in the last few days. So 2 insiders from the corporate side, 2 outsiders from the venture side, talking about also the global market for GDPR compliance, and a law firm with a practice, a European, US, also Asian practice for Asian corporates that works with hundreds of companies around the world on GDPR compliance. So 4 very different perspectives. The format we're going to adopt is our first 2 speakers will be up here together, Sabrina and Leila. Leila has some slides, but this is going to be quite interactive. It's more of a conversation between the 2 of you. Then we'll pass on to Marcel. Mirena will wrap up, but again, this is intended to be interactive, and then we're going to move into essentially a panel format. So if I could invite Sabrina and Leila to come up.
Thank you. Sure. Well, thank you very much, Burton, and thank you everyone for attending. I think this is a very important topic of conversation today, of course. Just a few disclaimers. These are expressions of opinion only. They do not constitute legal advice, and no attorney-client relationship is formed in any discussion here today. So with that, let's go ahead and dive right in to the many questions around GDPR right now. It's really impressive how much uncertainty there is around this subject, not only from the companies who are trying to comply with the GDPR, but also the engineers who are looking to develop new tools and functionality around really complex legal language. And also the regulators themselves who are still, through the Article 29 Working Party, explaining what they meant by certain provisions in the GDPR. So with that, let's do our best to dive in and address some of these questions. So first and foremost, what is the GDPR? Second, to whom does it actually apply? Who's impacted? Why should we care? When should we start caring? And how does it directly impact you and your work? So what is the GDPR? The GDPR is a European law on the protection of personal data. Now, the GDPR has broadly defined what personal data means. It's really any data that relates to a person, whether that person is identified or identifiable. This is a massive development as compared to existing definitions of personal data under European law, and it's much more broadly defined. It's meant to address new technological developments, which goes into a second point, which is EU data protection laws are pretty outdated. In fact, the e-privacy directive, which is in effect right now, was adopted back in 2002. And finally, the GDPR is a regulation, which means that it applies globally in all 28 of the European Union's member states. So that's sort of the silver lining here, whereas now we have to deal with implementation of the e-privacy directive in different countries in Europe. Now we have a global application. So as difficult as it may be to get ready and comply with the GDPR, hopefully there will be less implementation that is really specific to member states, and the laws will apply across the board, across the EU. So to whom does the GDPR apply? And this is what is really impressive, and Burton had alluded to this earlier. It really applies to all entities and even persons in some cases who are controlling or processing EU personal data. So if the data involves a European person, a company that's based in the EU, or a company that's based in Silicon Valley, or really anywhere globally, the GDPR will apply. So why should we care? I will give you my top 5 reasons. So first, it's the law, and we need to comply, or we will miss out on a $17 trillion European market opportunity. Second, even if you don't care, your customers will care. And if they don't care now, they will care very soon. Third, it's your company's reputation. Some of the measures under the GDPR are very difficult to implement, but in the end, developing a solid privacy and security program for any company is absolutely critical to doing business. And I fundamentally believe that with privacy and security programs up to par, this is a great business opportunity. Fourth, it's the right thing to do. If you think of the basis of why the European regulators came out with the GDPR, it was really to protect the personal data of individuals. And finally, if I haven't convinced you, let's get into the fines. There is a lot of noise around the fines because they are impressive and higher than really historically they've been in data protection globally. So there are 2 tiers of fines for non-compliance under the GDPR. The first tier is the higher of 10 million euro or 2% of worldwide revenue. The second tier is the higher of 20 million euro or 4% of worldwide revenue. So these fines are certainly impressive, but the reality is up until now and historically, it's been pretty rare that a European supervisory authority has fined more than about 1 million. But there is an upward trend. So just last year alone, the Italian supervisory authority fined 5 companies in the amount of 11 million euro. So we can see that there is the possibility of an upward trend and that these fines will be taken seriously by European regulators. For the higher tier of fines, these are for the more egregious abuses of personal data processing and controlling. These are things like really not respecting the rights of data subjects in violation of the GDPR, international data transfers, and others that are very important. As far as the first tier fines, the lesser tier, this is interestingly and arguably for certain security breaches. This was a surprise to some of us in practice, and I'll love to hear Sabrina's perspective on this as well. But that security breaches are falling into the first tier. So when should we start caring? Well, as of today, we are 88 days away from GDPR compliance date, but who's counting? The effective date is May 25th. So it's absolutely essential that if you haven't yet started on a GDPR compliance program, that you get started now. And I would just add to this, one of the most important ways to get started is actually by building into any products or services that you are building a principle called privacy by design and privacy by default. Not only is this a GDPR requirement, but it makes sense. It's so much easier to build privacy and security by design into every piece of software that you develop, every piece of code that you write, than it is to go back in time and clean this up after you've already released certain products. So take these principles of privacy by design and privacy by default seriously, because ultimately, as I said, this is good for business and will keep you in compliance with the European law. So how does this impact you? This is not an exhaustive list, but I'll give you just the high-level overview of some of the key operational impacts of the GDPR. And then I'm really looking forward to hearing Sabrina talk about how this has impacted her in her work. So first, know your data. This exercise of a global data inventory and mapping is required under the GDPR, and it involves understanding all points of data that you are collecting and processing. Who touches it? How do you handle it? And that relates directly to the Article 30 records of processing. Here you have to maintain, under Article 30 of the GDPR, detailed records of every single point of processing personal data. I mean, it's really an incredible undertaking. It's a lot of administrative work, and it's really about just keeping your information organized in a way that makes sense and that you can supply not only to your customers, but also to regulators. Identify the impact on your product functionality. So I had talked about this earlier. But the most important thing that you can do is really understand what products and features you will need to build in order to address GDPR requirements. There are things that we already know about, like the right to be forgotten, that people can easily delete their data, or your software and system allows the deletion of personal data. But there's also interesting requirements like the right to data portability. Can I export all of my personal data from your system and take it with me and put it into, using a machine-readable format, another software application? So you can only imagine the headache that this will cause certain companies like Facebook to develop a single way of exporting all personal data that applies to an individual. Conduct data protection impact assessments. Really evaluate why you're processing personal data. This requirement generally applies when there's a risk to the individual when you are processing their personal data. Ask a series of questions that make sense. Is the reason that you're processing this personal data, did you receive the right consent? Where is the data going to flow? Is it necessary? Are you collecting the data that's necessary to carry out the purpose for the processing? Develop new agreements, and this is a really incredible undertaking for legal departments. Not only do agreements with customers and vendors need to be updated, but also intra-company agreements. So if you have a subsidiary company or sister companies, you also need to evaluate the language in your agreements for the data flows within your company. Of course, I've also added the privacy statements. They need to be GDPR compliant. And the European regulators also want a lot of clarity around this, which may mean developing iconography, making things really easy to understand and read. You may need to appoint a data protection officer to manage your GDPR compliance program, depending on the nature of the activities that you're carrying out. Data breach notification is another interesting area because the GDPR requires a 72-hour notice period for controllers to notify supervisory authorities. That is a very short amount of time and has a huge impact on companies. And what's interesting, Adaptive Insights is a data processor. So we're evaluating this in the context of what are our notification obligations to our customers. Make sure that you have an incident response plan in place that allows you to meet these obligations.
Leila, how many employees does Adaptive Insights have now?
We just reached over 500.
500, okay.
So finally, ensure unbundled and verifiable consent. Now this is a really massive undertaking, in particular for marketing teams. You need to demonstrate that a data subject has actually given you consent, and how you got that consent, when you got that consent, which terms did they actually consent to. Now there are tools and features in certain software applications that will allow you to track this. And fortunately, companies like Adaptive Insights have done a great job with this already. But again, it's exactly what I was saying before. When you build in privacy by design from the start, it's much easier than having to go back in time and understand when you collected consent, if that was maybe 10 years in the past. So thank you very much. Any questions?
Yes.
Yes. So this announcement that Professor just showed on the slide, that there is going to be a location added, that European Union would allow for placement of the data on US servers. How does this change?
No, not
Did I
allowed for
understand this
placement. This is under discussion, new legislation in Europe that would give European governments, or maybe just European Union, the right to request data for European citizens stored outside Europe.
It's just for the request, right? So pretty much all the regulations like Hungary has, that Hungarian data can be stored on their servers only, still remains in place.
So I think you're talking about data localization. I think that's a little bit of a different issue.
Maybe there was some opening in data localization, but it seems that this is just a request for the data.
No,
Sure.
this is about where data is located and the ability to access data outside your legal jurisdiction for your citizens. Yes, sir.
Thank you for the presentation. So is there any standardized process for US firms to go through to make sure that they are GDPR compliant?
So there is no standardization. And a lot of companies are just trying to understand now what compliance actually means. And I think this is really, it's of course a destination, but it's also a journey. And I think that as we approach May, we will see a lot of different interpretations of the different requirements under the GDPR. And you will see companies doing different things to address these requirements. So it will be very interesting to see how this plays out over the next few months. But short answer, unfortunately not.
So one question from Seb, and then we're going to move on to Sabrina.
Sure.
How big do you have to be to comply with this? Like if you have an app with 1,000 users, do you have to worry about complying with these regulations?
Yeah, great question. So, so that is one of the points that we talked about, right? Are they 1,000 European users? Are you a company based in the EU?
Let's say it's 1,000 European users.
Then yes, you would likely need to comply. Now there are exceptions for certain provisions for companies that have around 250 or less. But in these cases, the exceptions are pretty limited, and overall there are a lot of requirements that will still apply.
But are some of these exceptions based also on company size, so numbers of employees?
Exactly,
Yes.
exactly. That's right.
So you're the smallest company we're presenting here today. You know, Uber and Apple. Obviously
Smallest,
are much-
but one of the good ones.
Right. So for startups, for brand new startups, when do these provisions kick in terms of numbers of employees?
There is no exception that I'm aware of.
Okay.
May 25th is the deadline. With that said, I think that European regulators are not totally unreasonable. I mean, they didn't just throw the GDPR book at us and say comply or find. I think that as long as you are making best efforts and your efforts are reasonable and you're on your path to compliance, I think that there will be a lot of leeway. That second tier of fines and even that Italian supervisory authority ruling that I had just mentioned were really for sort of egregious cases of abuse of data protection laws. So I think be reasonable is really the answer here. And of course, from a regulatory perspective, the more documentation that you can have to demonstrate your efforts to come into compliance, the better.
Okay, Leila, thanks very much. We're going to bring you back up. And so now Sabrina Ross is former privacy counsel, most recently at Uber. You left Uber a month ago?
Yes.
And you're now in private practice?
Yep.
And prior to that, you were at Apple for 2 years?
Yes.
About, if I recall.
Yep.
So much larger companies, just in terms of employees and revenues, than Adaptive Insights, and you've been working on this perhaps a bit longer than Adaptive. So Give us your impressions and what you see going on here in terms of the effect on Valley companies and your own experience.
Great.
Thank you.
Burton, thank you so much for having me. I'm really excited to get to talk to you guys about this. Often I speak to audiences of lawyers about how GDPR affects like legal departments. It's really fun to get to talk about, really focus on how does it affect product and engineering and sales. So that's what I'm going to focus on during this part of my talk is really those pieces, although folks are welcome to ask questions even as I'm talking, because I want to make sure this is sort of fitting into what you guys are thinking about. So Leila talked a bunch about sort of this applies to everybody. Even if you employ a couple of people, if you are processing data, particularly if it's sensitive personal data, you fall squarely within the regulation. And this is, I think, brought home by the fact that I'm seeing examples where companies are making key strategic decisions around market entry or market exit even because of GDPR. So I talked to a small publishing company that has, I think, about 10% of their users are in Europe, and they were like, the costs for us of complying are pretty significant. We don't even know if we should stay in Europe if the cost-benefit analysis isn't worth it. I've worked with another startup that said, we're definitely going to go to Europe, but it's going to take a lot of engineering resources to build data deletion and retention functionality required under the rule. And so we're going to delay going into Europe so we can focus our engineers' time on building other product features. And then in 2019, we'll try to tackle some of the bigger GDPR obligations. So I think one key question that is being impacted by the GDPR is around product design. Historically, in my experience, most companies have said, we'd like to have generally one product that works around the world. We don't want to have sort of different versions for every country. That's a lot of code to maintain and upkeep. We don't want to have a different privacy policy in every country. And increasingly, if the requirements around consent to data use are really different in Europe than in other parts of the world, I think some companies are saying we may actually have a different product or a different consent flow in Europe than we do elsewhere. We're seeing some bifurcation around product. And Facebook came out and said that they recently launched, in fact, you may have seen it if you use it, a program for facial recognition that's actually privacy protective. So they can recognize photos of you that other people have posted and then give you some control around those photos using facial recognition. But they didn't launch it in Europe, saying it was because of GDPR. So similarly, they have some artificial intelligence that can identify the likelihood of self-harm in individuals, so it's kind of around identifying risk. And they didn't launch it in Europe because they would have had to ask for particular consents around use of health data. So this raises another point, which is that under European law, unlike some other countries, certain classes of data get even higher protection than general personal data. So health, religion, race, sexuality, those kinds of things. So if your company is in those areas where that's kind of your core data set, I think there's an even sort of additional layer of that the GDPR will affect you differently. Let's see. So similar to that around product launch and strategy, I wanted to talk about the French Data Protection Authority, the CNIL, which recently launched a compliance pack with guidance for GDPR and connected car data. It's a really incredible resource because it goes through these very honed examples around different kinds of car data and how those should be used and how they should be minimized. And so a key question raised there is how can companies use data to improve their services? I think everyone accepts that you can get consent for data to provide services to your users, but pretty much all companies want to use that data to feed back into how to improve their own services, whether it's honing algorithms or making their machine learning smarter. And I think there's still a bit of an open question, which Leila referred to, around how does the GDPR apply to those kinds of uses where the company's doing it to get smarter? So going back to the French CNIL guidance, they say a data controller should not continuously process detailed location of a vehicle for a purpose involving technical maintenance or model optimization. So that's just one example when all of a sudden these kind of connected car companies are saying, wait a minute, so I can collect location only to provide a user service, but not to optimize my models. So I think we'll see kind of the ramifications of that play out. Briefly around sales, are lots of folks here in sales? I'll keep it very short. Privacy is becoming a key point of deal friction. So at this point, salespeople are getting trained and getting materials in their pitches on privacy and data security to make sure that they're framing it correctly, especially if they're in a B2B company, so that this doesn't become a sticking point down the road. So the last thing I'll say is about algorithmic transparency, which is not driven just by the GDPR, but by, I think, a lot of trends. But the GDPR says if you do automated processing about an individual that makes automated decisions that affect sort of key legal rights that might make them be fired or not be eligible for credit, you have to give some amount of transparency about what goes into the algorithm to make those decisions. And this is part of a broader trend of laws saying algorithms are doing so much right now, we have to give users some transparency about how they work. And so I think this is an area where, as Leila mentioned, it remains to be seen. What does algorithmic transparency mean? We know it doesn't mean revealing source code or jeopardizing your trade secrets. We know it probably doesn't mean something really high level like we use any inputs we have about you to make decisions. It's got to be more detailed than that. But I think we'll see a lot play out in the coming months around that piece of it. So with that in mind, I guess I want to talk a little bit, this is just me kind of giving some hopefully controversial and conversation-sparking opinions about pros and cons. I'm a privacy person. I believe in data and technology being used for good in all kinds of places, but I think building privacy in is important. So GDPR is going to be a driver in data deletion. I think to date, so many companies have said we can keep all data forever and figure out what we can do with it and monetize it, and that has some serious issues. So GDPR drives, you can't keep data after you no longer have consent and a justifiable purpose for it. So I think that's one of the bigger technical lifts is how do we delete data? And this is in a place where I think startups actually have an advantage over older companies. If you engineer in the ability to delete data early, it's way easier than a huge company that has to go through dozens or hundreds of systems to figure out how to delete across all of those systems. Leila talked about data mapping and data classification, identifying everywhere data sits. This is actually going to be a huge driver in terms of preventing data silos and getting, like to take an example, Apple, huge company, has data in lots of different places, getting different business units to understand what data one another have and ensure that there's not kind of overlap and excess. The cons, I feel like I've kind of alluded to. I think uncertainty can stifle innovation and that it would be a real loss to see a health startup or a health nonprofit that's really focused on serving underserved populations or preventative health. It's highly sensitive data, so we want to be careful with it. But if companies shy away because they feel like the risk is too big, then we're seeing a loss or a cost there. Let's see, what else?
Can you say a few words about how GDPR affects customer support operations? Have you had to deal with that part of the function of company in your work?
Yeah, so I guess I break that out into two categories depending on whether you're B2B or B2C. If you are consumer facing, then you are the controller of data. You directly, under GDPR, have to do things like respond to subject access requests. So if somebody says, I want all the data you have about me, companies have to build a tool to pull all the data they have about that person and provide it. So building out scripts for customer support to use, tools in order to pull and transmit that data is a huge piece. If you are B2B and you're not the controller, then your customers are going to say to you, hey, service provider, you have to help me be able to respond to those subject access requests. And I think actually that another point is that where there's regulatory uncertainty around GDPR, some of it is actually going to be driven by companies who are saying, if I'm the controller and I'm directly on the hook for GDPR compliance, you companies who work for me, I'm going to tell you what I think meets the legal bar. And so service providers are often in the position of, they might say like, I think that bar you're setting is too high. But if all the customers are demanding it, it will sort of de facto set what compliance with GDPR looks like in some areas.
But does this affect the types of conversations that consumers can have with customer relations teams? The type of data that customer support teams are collecting from customers and how that's handled?
Interesting. I mean, absolutely, in that it provides a new right where customers can say, you have to give me all the data that you have about me. I think it also potentially impacts sort of how much data about a customer support will want to collect, because then we have to identify it as another repository and disclose it upon request. Is that helpful?
Yes.
Yeah. So now I think, let's see, I will switch gears quickly and talk a little bit more where Leila left off about what companies are doing to comply with GDPR, sort of at a practical level in terms of resources, who bears the brunt of it. I think the number one most common thing I would say is that I'm seeing cross-functional GDPR steering committees, which is to say you can't take, sadly, me, a lawyer who can't build anything, I can't build data deletion, and say, Sabrina, you're responsible for GDPR compliance. No, there really has to be a product person, an engineering person, who are sort of jointly on the hook, who are defining together what are the objectives, how do we achieve them. I think CEO and board involvement, I've never seen such high CEO and board involvement on any other legal development that I've worked on. I mean, it just doesn't exist. If you take like a marketing privacy law, people know how to go and execute against that. Okay, people have to be able to opt out. I mean, this hits the core of what can my company do with data? How long can it, how can we monetize it? How long can we hold on to it? And CEOs and boards care about that. Sometimes the audit committee cares about it. If they think that the risk of GDPR is material, they want to be involved. So it's really hard to talk about kind of resources because they vary so widely, depend on the kind of company and the size of the company. CEB of Gartner has said that the median privacy program of mid-sized companies has allocated $350,000 to GDPR compliance, and that staffing is like more than half a lawyer and then more than another non-lawyer headcount. So whether there's somebody in compliance or IT or security. Leila talked about data mapping. 54% of organizations are undertaking formal data mapping. So often that requires like sending out a survey to every business unit and collecting from them, like what are all the data sources you use, how are they stored, how are they protected. So again, companies, even with data mapping, can get bogged down in like, how do we get our arms around what we have? Let's see. PIAs, privacy impact assessments. I think that's a huge one. Technically, there's no retroactive requirement, I don't think, to go back and do a privacy impact assessment on anything you've ever done. I mean, that would be, for some companies, thousands of privacy impact assessments. But many companies are, at least for their riskier or more data-intensive products or features, doing retroactive ones and saying, let's say I rolled out a facial recognition feature 2 years ago, I'm going to do a privacy impact assessment now to show that I considered the privacy risks and kind of how I came out on that. One other point about coming into compliance versus staying in compliance, I think the huge lift is right now around, like I said, re-architecting to do deletion, reconfiguring how consents work, but there will be a certain amount of ongoing compliance activities. Keeping the data map up to date, maintaining a regular list of your vendors who have access to personal data, doing a regular reevaluation of your security and whether your security is appropriate. So although we're all pretty focused on May and being kind of ready for May, it'll be really interesting to see what does long-term compliance practice look like. What does that staffing usually entail? There's a lot of great resources now, and then I'm going to stop because I feel like we're running short on time. The UK data protection regulator has a helpline for small organizations who can actually call in and ask questions. They've released a ton of guides, like I mentioned, some specific to industries like There's one for health from the UK National Health Service. There's some from Connected Cars. So depending on where you sit, there's definitely kind of resources out there. I will pause there to make sure there's time for everyone.
So thank you, Sabrina. We can take one question. Sabrina, yes?
Can you maybe just keep it brief, but how vigorous do you expect the enforcement to be for this? Because, I'm from the US and we have data privacy laws that are not anywhere near as serious as this, but we've seen serious leaks in the past, 18 months.
Yep.
And it doesn't really feel like much has been done to find those companies and to preempt further leaks. So how serious do you think they're going to go after people and really make sure that they're following the rules?
Oh, I love this question, and I keep saying that I should get together like a betting pool of other privacy people so we have some money riding on this.
I'm in.
I think they're serious. I think there's a lot of room for speculation. Will they go after an egregious violator first? Someone who isn't even making an effort to comply versus somebody who is imperfectly deleting data and forgot some server somewhere. If I were a betting woman, I'd say they're going to go after some egregious violators first, and that they're we'll try to set the bar via enforcement, similar to how the FTC has, where the laws might be gray in some areas, but through kind of a body of work, they'll be conveying what they actually expect. I'm too scared to speculate on fines. I don't think that they would start with the craziest level of fines. But I'm not sure. And the breach one is really a really interesting question, because reporting in 72 hours, even with best intention, is really hard to even just get enough facts together then. So I'm very curious about that particular one. Yeah.
So one of the points Sabrina touched on was how some companies are delaying product introduction in Europe, in your experience, as much as up to a year. So when you consider that customer support teams for these products introduced out of here into Europe, customer support is typically done out of Europe, so Ireland, for example. These delays in product introductions can have a big impact on employment in Europe. So this, I think one of the cons of GDPR, which has not really been assessed properly through proper impact assessment, is this is going to retard hiring and employment in many European markets around certain IT, so perhaps more consumer-focused software and data products. Does that sound reasonable?
Yeah.
But there's a lot of hiring going on in the area of data privacy.
Yes. Okay. Well, thank you very much. We'll bring you back up when we've finished going through. Thank you. So now on to Marcel. So Marcel van der Heijden is based here. Representing as a partner in SpeedInvest, but also Vice President of Business Development for Aircloak, a GDPR compliant startup out of Berlin. So you just got back from Vienna on Saturday.
Yep.
Yes. So please tell us what's going on at SpeedInvest, the vision from the venture capital perspective, but also how does Aircloak see this as a European startup,
Sure.
kind of focusing on this market?
Sure. Right. Thank you for having me here. So yeah, I can talk a little bit about the GDPR impact on the industry from the perspective of Aircloak, a company that I'm working with very closely, but also from the perspective of SpeedInvest, in which I'm a partner. We have about 80 startup investments, early stage startup investments, and all of them, most of them have to kind of look at GDPR and what's the impact to them, and we get stories and concerned calls from them as well. So as an introduction, we're a 145 million early stage investor. Started in 2011, investing in European tech startups, very active in fintech, but really broad and agnostic sector-wise. I tend to work mainly with our technology startups, and those are the startups where we typically see opportunities in Silicon Valley. So we're headquartered in Vienna, but we have an office here in San Francisco where we help our companies develop the US market. We're about 80, there's a little mistake here, we have about 80 investments. 9 exits actually to date. Funds are doing really well, I should say, and we again invest across sectors, but all of it is digital. We rarely do hardware, no bio, no pharma, those sort of things. What sets us apart is kind of two things. We invest capital in startups, but a lot of startups that we see in Europe and the European ecosystem is still a little bit different than the US. They need a lot of help, so we take on operational roles in these startups, which means we become part of the team for 6 to 12 months, agree jointly with the startup, milestones that we want to deliver, and if we deliver those, we get some equity for that. So it's a sweat equity model, but it's performance-based, and so there's upside for everybody if we manage to, help these companies, and there's downside protection for the founders if we don't manage to do that. Secondly, for a European fund, we are one of the very few funds, and certainly the early stage fund with the biggest representation here. We have about 3 people here now. We're hiring 2 more, and we're hiring right now. So, those are feet on the street that are resources that our startups can benefit from. I'm not aware of any other early fund in Europe that has that level of resourcing. And our investors are high net worth individuals from the German-speaking countries primarily. Including some kind of cornerstone investments, well-known brands globally, as well as NEA, New Enterprise Associates, which is a very large fund here in the Valley. And they've made an investment to basically see some of the best deal flow in Europe. So, talking about the compliance market, I couldn't get a lot of data around the size of the GDPR market. I think what's closest is to look at the governance, risk, and compliance markets overall, which is a 22 billion market. It's about a fifth of the overall security market. And actually, most of the spend in that GRC market is actually services. So, compared to security, there's a lot more services, professional services, consultancy being delivered in this space. And I think I'm seeing that in GDPR as well. There's a lot of people are being hired, a lot of consultants and lawyers are being hired. So the spend, I think, is driven there. How large the market is, well, maybe we can look at what companies are saying. So PwC did a survey where US multinationals, 50% said GDPR is their top priority. Only 7% said it's not a priority. So there's a high level of visibility and awareness, as we've heard before, among US multinationals. In EMEA, and they're planning to spend, most of them planning to spend 1 million or more. That is actually not a lot of money if you think about the amount of revenues these companies would generate. But those are the numbers that we're seeing. A survey in EMEA gave a little bit of a different picture, and this is a survey across companies with a very broader spectrum of size, where 40% of companies spend less than 100K. I think those are probably the startups, types of companies that we invest in, very small companies, whereas 15% spend 5 million or more, and obviously those are the larger companies. So there's a large spread of how much companies spend. And frankly, it's probably how much they think they can spend sensibly. So how ready are companies? Again, a very mixed picture actually. If there was a survey of the FTSE 350, Fortune 500, where 94% of companies believe they were on track for GDPR. I think this was about a year ago, and I think it's wrong. I think it's nonsense. But I think maybe a year ago people felt quite good about where they were, and I think people started to realize it might be a little bit more complex than they expected. Less than 50% had an internal GDPR task force at the time. This sounds incredibly low, and about half had done a GDPR impact assessment. Again, this is really, really low. I think these numbers by now have changed. But the numbers that I think this was January 2018, a recent Deloitte survey came up with, are more representative and maybe even more honest. So they did a survey, and 15% of the companies they met with or spoke with said only 15% expected to be fully compliant in May, so in 88 days. Right? I think that's fair. This actually resonates with what we're seeing at Aircloak and within our own portfolio. I don't think anybody really knows what it means to be compliant, on May 25th. And certainly everybody, any company that I speak with, they think they're trying to get somewhere. They're trying to be able to show that they've made a good effort. But they're actually planning 2, even 3 years out in terms of their budgeting, for example, because they know they have a lot of work to do after May 25th. So are they ready? I think everybody's out of the gate by now, but a few people still have some ways to go to the finish line. So what are we seeing? And this is actually an Aircloak perspective. And Aircloak is, we're a technology company. We deliver technology solutions to enterprises to help them do analytics on personal data in a compliant way. I'll talk a little bit about that later on. But we're seeing actually quite a big shift in the last year. Last year, a year ago, when we started to talk to companies, usually you would talk to the chief privacy officer or somebody in the legal organization that was responsible for privacy. At least they had somebody that owned privacy, but rarely was there a budget, let alone a substantial budget. So there was a little bit of budget, maybe to hire a few people. That was basically it. There was no budget, privacy-related budget with functional owners. And with that I mean a security person, the head of data, the head of data protection, the head of CRM, the marketing automation person. There just were no budgets lower down in the organization, and actually, there was no ownership as well. So there was, a small legal team that had some ownership, but they had no means to push that down into the organization. And so that meant that there wasn't actually a lot happening at the time. I'm sure there were a lot of meetings. Looking at it today, and it almost felt like December was a big switch there. Now, today, I think in many companies, there is budget in the security organization, in the data warehouse organization, et cetera, et cetera. There are owners. Everybody knows what they need to fix, because all the assessments have been done last year. Everybody knows what needs to be fixed. And people are fixing it. And what they're fixing, I think you gave a good summary. What we're seeing, they're fixing their plumbing. They're fixing understanding where's my data. A lot of companies don't know where it sits, or don't have a good map. Where does it come from? Why am I actually holding it? A lot of companies just collect as much data as they can afford. So they're going through this whole rationalization of collecting, processing, and storing data. And that's where they are today, and kind of the higher level use cases around how do I use personal data for analytics, how do I use it for predictive analytics, for example. A lot of companies aren't there yet. So top sectors, we're seeing financial services and healthcare. These are already highly regulated industries, so they're familiar with what to do when a new regulation comes around. In the US, we're seeing the large and the global online players, the Facebooks, the Googles, the Ubers of this world, that are investing in privacy and privacy technology very deeply, and actually sharing some of that through open source initiatives. Among startups, it's a very different picture. Frankly, they're scrambling. The good thing is they are flexible. They have built maybe only part of their technology stack, and they're still able to course correct and build build privacy by design, basically, and they're doing that to the best way possible. But they do not have good access to information. So they Google around the ICO in the UK and has some good papers, but they are not able to hire the legal advice, quality legal advice that they would ideally need. So they're doing what they can, but they have, by and large, a wait-and-see approach. So they're going to see what's happening in May, where the regulators will emphasize, what areas they will emphasize, and they'll kind of roll with that. But they can't really be very proactive at the moment. Incidentally, and anecdotally, we're also starting to see GDPR trolls. So law firms that are starting to send out cease and desist letters. If you don't have double opt-in for your newsletters, they'll send you a letter with an invoice. I don't know if that's a trend, but it's out there. And if we think about the impact on industries, obviously the size of the market is much smaller than the impact on the market, the 17 trillion European market. I think there's an existential threat for some businesses that GDPR represents, and I'm not hearing many people talk about it, but I think we'll probably see some interesting things happening in the advertising space, in the marketing automation space, advertising networks, demand-side platforms, and so forth. From an investor point of view, or from a technology point of view, I'm not seeing a lot of fundamentally new privacy technology breakthroughs. Differential privacy at Uber, Apple, Google all announced it. That's probably a big one, but the research is very concentrated inside of big, large technology companies, inside of universities, and Aircloak is a spin out of universities. But there's not many startups that are trying to build systems that are easy to use and provide good levels of privacy protection, surprisingly. I know of two, there's probably a few more actually, but there's Privitar, who did a 16 million round, which is a very large round for the stage of the company, and Aircloak, we invested in a 1.3 million seed round with them about 9 months ago. 1 minute on Aircloak. Aircloak built a solution which is actually a privacy layer that sits in between a database and an entity. It could be an analyst, could be a business application that wants to query the database and wants to query personal data. Aircloak, by design, prevents personal data to leak out of the system. And that's been confirmed by the French CNIL. So the French CNIL, the French Data Protection Authority, evaluated our solution and confirmed that it meets all the requirements for anonymity as defined by GDPR. Now that has a lot of benefits for companies, including one of our companies, which is part of the second largest bank in Germany. They hold a lot of customer data, some first party, some second party. So this is like an account aggregation type application. Teambank was unable to do compliant analytics on this data. They had a very complex process to do that, both organizationally very complex as well as technically very complex. It took them 6 weeks from somebody deciding or submitting a proposal to do an analysis to the chief privacy officer approving it and that person being able to run it. And then if the outcome wasn't what they expected, they had to go through that whole process again. Teambank deployed Aircloak. The CPO basically convinced the organization that it delivered the level of anonymity that Teambank requires, and now this process is gone. It's effectively an instant process. I'll skip this. We're working with a bunch of companies, globally, in the US as well as in Europe. Again, mostly from the financial services sector and in healthcare. But that's it for me.
Thank you, Marcel.
Question? Sure.
So we have, question, Nick.
So while there's a lot of attention talking about GDPR, probably a lot of confusion about it, from the startups that I talked to, it seems like, kind of like you mentioned, most of them are taking a wait-and-see approach, trying to see how strict the enforcement is going to be and how much money do they really have to invest in compliance. Is that what you've seen as well, or is that starting to change?
Yeah, they do what they can. They try to do the obvious things, the easy things. Usually they're pretty flexible, so they can get quite a lot done. But beyond that, they don't have a lot of good information, so they struggle to take the next step and make further investments. Obviously, they don't always have the resources. So, they do what they can, and then now it's wait and see.
One more question. Anyone new? Okay, Seb.
I'm curious, what do you think will be the impact of companies actually started in Europe?
I don't think it will have any impact, to be honest. We see thousands of companies a year as a fund. I haven't heard anybody saying, well, I wanted to raise some money, but now with GDPR I decided to, find a job or... So I don't think it's going to have an impact. It will be part of the plan, and it's part of our due diligence now to ask them, hey, what are you doing? What about GDPR, and how are you going to deal with some of these things? So far, I'm not seeing an impact.
Okay, thank you, Marcel.
Good.
So our final speaker is Mirena Taskova from Fieldfisher, representing the perspective of legal practice which focuses, a global law firm which focuses on GDPR as one of its major legal practices. So, Mirena, thank you for giving us the law firm perspective on this.
Thank you very much. Well, you're using my personal data right now.
Okay.
Thank you for that. I have my consent signed. So I would not speak too much about law today. That's not my intention. And thank you very much for the disclaimer. I have this disclaimer. There is no legal advice here going on.
Sorry, that's your cover story.
That's my firm. So just to say that this law firm is a European law firm. We have also offices in China. We do a lot of privacy for many years. Today I will focus on a few things that I think that might be useful for the audience. Hello. One of the things that I want to talk about today is the pros and cons of the GDPR, because there are also pros, not only cons. I would like to talk about the roles of every company in the United States, for example, and in Europe, and why we should care about GDPR and how can we tackle GDPR. And the last thing I'm going to talk about is basically my personal experience during the years about the privacy laws in Europe and what the big clients and small clients care about and how they deal with this issue. So the first one is the GDPR and what are the pros and cons. And this is with response to your question about the startups. GDPR will start in May, but there is still law about privacy in Europe. And this law is from like many years. I'm working 10 years already in European law. And this European law is very similar to the GDPR. So Europeans are not exactly surprised about the GDPR at all. The good thing is that you don't have any more 28 laws to deal with, because I can assure you that there's so many different perspectives of how these European laws have been implemented in terms of privacy, who has data protection officer, who doesn't have data protection officer, do I have to pay a fee so I can, in terms of objection for direct marketing, should it be for free? So all these little things actually could be very annoying before, and especially for a new company that wants to establish global operations. And technology would be always smarter than any law in the world, I believe. I think that really slowed down the business. GDPR, one positive about GDPR is that it uniforms all these local laws and say one rule, what has to be done in Europe with respect to privacy and use of personal information of people. So that's the good thing. The bad thing, we had different laws, but we had a lot lower fines. Now these fines are exponentially increased. And we're talking here about 20 million euros fine, or like 4% of global turnover, which are very high fines. And one of the reasons why many companies are starting to get focused about that is because of these fines. So whether there would be, again, to answer your question, whether there would be an enforcement, I don't think anybody knows. Really, I don't think anybody knows, but the good thing about that is that there's so many practical, practical things that you need to start thinking about when this law already is enforced, that only this will tell you and will create kind of precedence of when and how this law would be enforced. Unfortunately, now we have only theoretical guidance and practical implementations to the best of our knowledge, but there is no court cases because the law is not yet enforced. This is what we need to look for the next 2-3 years, and they're, I think, crucial for how we are going to perceive GDPR in the future. Then I would like to talk about the GDPR and how the company should deal with it. The first thing I would like to mention is the most important thing, according to me, is define what are you doing and why are you doing it in terms of personal information. You have one side, a lot of companies who are taking personal data from either from the individuals, B2C, or working with businesses, B2B, but they're using this personal information for their own needs. You say what you're doing with that personal information, how you're using that personal information, and whoever you share that personal information with basically has to do whatever you say. So these are the controllers. I had one T-shirt for data controllers that I wanted to put today, but I decided I'm a lawyer, so it's too conservative. Anyway, then you have data processor, which is also very important, but data processor is the one who is doing whatever the data controller is saying. So basically, I will tell you what to do, and you need to obey. It is very important to define who are you, because your obligations are slightly different, if not substantially different, and that's going to impact your entire process when you go to the data protection impact assessments, or if you have to go to these data protection impact assessments, when you go to your records, when you have to decide how are you using data, what are you doing with that data. And now I will tell you why actually I find this to be super important is because of certain clients that we worked during the years. For example, companies that are focused on consumers, they have to put a lot of attention on their privacy policies. How do they present this information to these users? Do these users know what is done with their personal information? How do they learn about these extensive, significant, long privacy policies are not really in favor of GDPR. On the contrary, and there is no standard procedure of how this has to be done. People are still thinking, and big companies, I wouldn't mention names, but there are big companies who are making designs on different emojis or icons, how this to be done. We are still in process of implementing that. The most important is it has to be easy for every user to understand what's going on with his data and who has access to this data. It looks actually very simple, but it's the most complicated thing is to make something very simple, I find. Then the other thing that I personally experience is the contracts, especially if you are the one who is following someone else and has to follow instructions on other companies who have their own internal procedures and who have their own internal rules how things to be done. It's very important you also to establish your internal rules, even if you follow someone else's decisions about this personal information, and basically say and put your position and say, I know that I'm going to use your personal data. I know that I will follow your instructions, but you also have to follow my certain rules that I establish internally because I process personal information of many companies. And this is not very easy things to do, to follow different rules all along. So this is something that if you are acting on behalf of another company, think about, to facilitate these companies, of course, but to create a uniform approach of how these things to be done. An example for that is the so-called sub-processing. There are many companies who are hiring many other companies to help them to use that information. It is very difficult to inform everyone about each of these additional companies, and when you decide to hire them, this significantly slows down the operations. It's super expensive, and that's why many companies, for example, create lists. You sign up for a list, and as soon as I know what's going on with a certain company, I sign up and you are informed automatically. This is something that can be standardized. If you're on the other side, for example, if you are on the side of the company who is deciding what to be done with personal data, I think that you should very much focus on security breaches, especially if you have contracts with other companies who are using personal information on your behalf, because the GDPR envisages audits. It's very difficult for a controller to be able to go and see what every single company around the world is doing with this personal data, but in the same time, this company is responsible for that personal data. That's why, again, there should be some kind of standard, third-party certification that should be able to create this type of evaluation, whether someone is in compliance or not, instead of every company just spending tons of resources of dealing with that. These are the main things that I consider super important. Again, contracts, again, consents, with the privacy policies, and last but not least, training. I think people don't focus very much on training of their employees, and it doesn't matter whether you have 5 employees, whether you have 10 employees or 70,000 employees. You need to train these people, no matter whether they are from product teams, IT, marketing, especially IT and marketing, what to do when a new product is launched, when there is a revision of existing product. I know that marketing departments specifically are very enthusiastic about the launch of new products, and this is fantastic. This is how we actually personally experience these new products. But it's very important for the company globally, for these marketing departments and other product teams to know what has to be done with this personal information, because very often there is a product that is already created. Then this product, as soon as it's about to be launched, is going to the legal team, and the legal team says no. So the legal team becomes like the bad guy in the situation, but in any case, this product has to be changed. And this costs a lot of money. So that's why it's better if you just train this personnel to know what to do with that personal data. And here is the funny thing. There is not many training solutions about people. For example, it is easy to train 100 people. I can gladly do that here. But what about if we have a retail company, not only technology company, that is having 50,000 employees? It's super difficult to train these people. There's no yet solution for that. We are, working on different ways to do that. There are questionnaires, there are videos, which we are trying to do. But in general, these are the most important things that I would like, people to focus their attention on. Okay. And I would open for questions. If anyone has questions, happy to answer.
So we are going to do questions. Obviously, we're over a bit, but let's go into panel for 5 minutes. Yes, in the back.
I was wondering about B2B. I don't know to what extent GDPR applies to B2B businesses. Let's say our company provides some enterprise software, and then there's an employee of a customer logs into this application, they go around and they use it. Is that company then subject to GDPR compliance?
Yes. So with the B2B business, I would very much focus on the contracts again. So both businesses decide who is using the personal data for their own needs, and who is using personal data because the other company wishes so. And then focus very much on the contracts. And there is specifically in GDPR provision, it's actually Article 28. I would not go into details, I don't want to bore anyone. But you definitely have to focus on the contracts with the other business, and the one who is deciding what to be done with the data has to determine, who is using that personal data, specifically security measures, who is taking care of these security measures, when are they going to inform you for security breach? Because this 72 hours notification for security breach is kind of vague, because it's 72 hours from the moment you actually learn about it if you are a controller. So you have to think about what is your role and to impose certain obligations on the other side.
But are you a person or are you an employee? So let's say I'm the customer, and I go in and I use the software. Can I then ask the vendor to delete everything I have done, even though I did it in terms of being an employee?
Are you an individual?
The vendor might destroy all kind of business records as well.
Well, I first of all have to decide, who are you and in what capacity you request that.
You are an employee and you're using B2B application.
So you as an employee of one side of the B2B.
Yeah.
Okay.
The question is if the provider of a B2B application, if he needs to be GDPR compliant because of the employee of the customer using that application. Because he's using the application in terms of being an employee, not that person.
Yeah, I understand, but in many cases you have to be in compliance with the GDPR, but how you have to be compliant depends on why these employees are accessing it. I will be happy to talk about it
Let's
after.
take this offline. Yes.
Can I just add one
Yeah,
more
Leila.
thing to
Leila.
this? So the way that I look at the relationship between B2B and B2C, and in particular for these companies which are data processors servicing other businesses which then interact with end users, is the data processor's obligation, in addition to the Article 28 requirements, is to really allow their customers the tools and functionality in that software application for their customers to be compliant. So hopefully that may help address the question you're asking as well.
Yes, sir.
If an EU citizen signs up for a service like Google while they're in the United States, can they ask Google for all the information that's been collected about them? And how would Google know that that person really is an EU citizen?
Yeah, it's a good question.
Okay.
Did everyone hear the question?
You're asking a really interesting and complex question because it's important where are you located according to the GDPR. Where are you located? Where are you based? So if you are a European citizen based in United States, this is a controversial topic. If you are based in Europe and you're not European citizen, GDPR may apply again. So GDPR applies of where you are located in terms of where you reside.
Where you reside or where you are located?
Reside.
Well, I'm thinking of the case of a European Union citizen is in the United States vacationing or temporarily for some reason, and they sign up for a Google service while they're in the United States. Can they ask Google for all the information that's been collected about them?
So it's such an interesting question, and I think it highlights the extraterritorial reach of the GDPR. And also, let me just kind of ask you a different question. So from a marketing perspective, just think of a marketing team. Everyone has a gmail.com email address. How do we really know if that's a European individual or an American saying that they want access to all the same GDPR rights? It's really going to be impossible to tell. So I think as a best practice, it's probably best to consider that you are dealing with a European if they say they're European.
And even beyond that, I would just say, I think going back to this, like whether there's going to be a product bifurcation, I think a lot of companies will say, all right, now that we're doing subject access requests for Europeans, we're going to do them for anyone, even if it's not legally required. They're already building the tools for it.
This gentleman has a question.
Quick question. There are trading hubs in Europe, which deal with transshipments, right? I know of some of them, like Maersk and those kind of guys. Are they covered with the GDPR? So if they deal with data of trading data between two different countries outside Europe, but the hub is located in Europe.
Sorry, what do the apps do?
Now there are these trading hubs like in Belgium or other places, right? Which basically are transshipment or they're just ports where trading is happening between two non-European countries. But then the transaction is happening and stuff like that within this thing, within Europe.
So what's the data? Are we dealing with European data?
Shipping data, customer data, invoicing data, that kind of stuff.
Are the customers European?
Sorry?
Are the customers European? I think the question is
No, the
always...
end customer is not European.
Okay.
But the transaction,
The processing is
the
happening
data,
in
the
Europe.
processing
Yeah,
happens in
so
Europe.
then you're under
Transshipment through
GDPR.
Rotterdam.
Controversial topic or just clear on this?
If the data is processed in the EU, then the GDPR applies.
Okay. Marcel, did you have any further comments you wanted to add on Aircloak? What it's doing?
No, not really. I think somebody made a comment. So, I think every company is processing personal data, at some point, and there's a lot of companies that share this data pretty freely internally, and we're seeing more and more companies saying, hey, we want, our internal stakeholders to access as much data as they can, but obviously that's not possible within GDPR. So I think it's also to some extent a cultural issue. How freely do you allow your employees to see personal data or derive personal data and allow them to kind of do product improvements, for example.
Sabrina.
Can I actually ask a question about that? I wanted to make sure I understood the product. So for example, would Aircloak let a data analyst run like an analytics query without seeing the underlying personal data? They could understand That's the kind of functionality.
Yeah, so normally they would run a query against a set of
The raw,
personal data set.
yeah.
And now Aircloak sits in between, so we pick up the query, we analyze it, we run the query on the
Yeah.
original database and anonymize the result. So the output is not subject to GDPR.
Great.
So I think we're at the end of our session. I'd like to give our speakers a round of thanks. Thank you. So just a small thank you gift from Stanford Mechanical Engineering for your time and effort. Do any of you, just a final couple of words from each of you before we wrap up? Final thoughts on GDPR in Silicon Valley?
I mean, it's so hard to summarize. I feel like we're in a really exciting time. I mean, how many of you, your companies, like, are primarily driven by data and what you can do with it? I think it's an incredible time to be seeing this, like, transition around that there's, like, ethics classes in engineering about the ethics of accessing and using data and algorithms. So I think it is really exciting. It can be easy to feel bogged down by, like, oh my God, what is a data map and how do I do it? But I also think, like, there's some really exciting parts of the law.
Any final comments?
Yeah, I mean, I echo exactly what Sabrina said. And as I mentioned earlier, I really fundamentally believe that privacy and security are good for business. And this is a great opportunity to showcase your company and what you're doing to be in compliance. So with that said, just one quick plug. Adaptive Insights has 500 employees, but also 3,700 customers, and we're a $100 million company that's growing at an incredible rate, and we're looking for a security engineer. So if anyone is interested, please come and talk to me. But thank you very much, Burton, and the rest of the panelists. I also learned a lot.
Mirena, any final comment from
Yes.
Fieldfisher?
Yeah, absolutely. Actually, mainly for me. If anyone is interested to build nice design tools for GDPR, so it can make life easier of people who are using the services, or also internally for the employees, that would be great. There is so much need for effective implementation of privacy policies by appropriate designs, and also security measures. Cybersecurity experts are absolutely, this is the right time for you guys. I would like to thank you very much for your interest in the GDPR. Thank you very much for the kind invitation, and let me know if you do something with GDPR. I'll be very much interested to hear.
So, reminder, next Monday is the State of Tech in Europe with Marco Marinucci and Janae Tier from Crunchbase and Mind the Bridge. Please join us. Thank you, and drive safely.